If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here. Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, especially with the official bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
It's covering all the official bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the same issue to telling you didn't give a shit about what I had to say.
Okay, hold on. Listen, Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers just cheating, agreeing, telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Against me this entire time. No one has made her answer that.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means that you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was.
I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside. That's what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt.
My objections on the record. You can make 5 feet. So you're
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me, is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me, because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
And in your honor, again, you're trying to spin this here.
I'm not spinning.
My objection is based on you not allowing me to do it. And that's when you told me my objection to be.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once permitted on the why it's on the prosecutor to prove those things. There's false words and irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to keep.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Like put on record that if whatever you would like to do from there, you can, because I'm open until these things. Like I say,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Please arrested Mr. Crusoe while he was in Huron Township, but if our district court has jurisdiction over offenses that occur within the township, both civil and criminal and.
Did you appeal Judge Green's decision on that motion?
I'm investigating because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct? I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to...
The judge can't just come in here and say that there's.
Yes, the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they're submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, judge said that.
Fine, then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
All the reasons that I've stated, there's
Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's two motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, the thing is what I'm saying.
Mr. Purcell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or no? Do you want me to set aside those default do you want me to set aside the default set asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay. Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Oh, excuse me. Motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used.
Okay. For example.
You use motivated.
Okay. Motor vehicles, pretty much a term of art in our business.
Law of differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go, all of everything's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cazell.
It is.
No, Mr. Cazell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Listen. Well, then that's why they have appellate courts for the fourth or fifth time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's my other issue with trying and my emergency stop, motion to stop this.
I already ruled on that.
Certain back, acknowledge my motions for my next travel. Nothing to do.
Once again, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole travel thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep, each judge has done the same thing. They just keep setting it aside. And acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my end.
What's your case that traveling doesn't mean operating?
I'm accepting the fact that this court's violated my due process rights in every way, the judicial bias and the fact.
All right, then appeal me. But today we're having a jury trial.
An unlawful jury trial, and I think that late statement I need to get on the record.
Right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
It violates my rights to a fair trial. 100%. And you want to keep overlooking. I know that makes you seem like they're not a big deal, and
No, your rights are a really big deal.
obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, oh, just because I agree with her on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me.
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling. The right to travel was when you did it by Shank's mare. Then appeal me. That's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American Jurisprudence sites that literally state that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this has been something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
Point, I must be complaint as well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that,
I mean, the process we're kind of.
which is not an appeal.
Is an extreme, lawyer when there is, there's bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be here.
But you didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Crusoe, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me my wife days before any of this even happened and talked to us about the traveling, even told me I was well within my rights, gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me, he even called me trying to I was like, what's that over me? And then he goes towards the motor vehicle. And then he tried to get me to not pursue legal matters. And then he's mad at me. And then the day that I filed for my body cam, I'm getting removed from here on a little league.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here. And I told you, that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, every time I force it to make my case, basically, the court keeps setting all my stuff and not allowing me to be heard.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How will there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my defense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single bit, and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, it's not. I'm not testifying. That's what I'm saying. It's the amount of traditional bias in this case.
I'm done hearing about bias. You need to appeal me. I don't feel I have bias.
Well, I don't feel that I would have a fair trial here with everything that's been taking place. Why I had filed policy? Why I did be.
And I've denied all these things.
Well, of course you can deny it. Again, showing again that this.
Once again, Mr. Crusoe, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Tina Green told me that she was just bad housing myself against the Secretary of State will make sure guys do this isn't a big deal. Right? Showing.
I'm not going to.
It's no impartial sport here.
I've never brought a Secretary of State, have I?
This is where this all stems from. These are the things I've been trying to get noticed. This and talked about.
What do you want getting noticed that we're not getting noticed?
The fact that this is collusion.
It is not collusion. What? All right, listen. What are you going to do today? Because I'm ready to bring the jury and I've denied all, stop. I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
It's not, again, Your Honor, it hasn't established, nothing is even put in here, right? And especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to 4. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
There's no way they're gonna be fair trial.
That didn't answer my question. I need to know how I'm going to proceed because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial.
I do. So it's against that.
Okay.
And that everything is on.
Okay. Okay. No, let's on the record as you feel they should be.
I brought the sites that I left the sites at home and bringing up the person's jurisdiction.
And hold on, once again, I want to just, because he just walked in the room, once again, I want to let you know, there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, the sport actually, who was supposed to be.
And that ain't gonna happen.
Anybody showing you were supposed to release yourself. It's in the book.
And I don't think I've shown bias. That's what we keep, once again, you and I disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong. That's just the reality of it.
That's what I have to do. Because clearly this court's not going to rule it the way it's supposed to. Not going to stand by your jurisdiction.
Not by your definition, I'm not.
The Secretary of State, Attorney General, and you have never heard anything. You can move lawfully and conceded it. You can say that again. It needs to be proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Statute, Michigan statute or Michigan court rule says I've got to do that.
I have it in there. My father was in this motion.
So you're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file it with the state and you provided one X. That is what you have to ensure.
Okay, then I don't have it. You can file that motion to dismiss with the circuit court. But we're having a trial today.
We're going to have Bob Williams participate in a trial that's going to be impartial against me, right? It's going to be completely. There is no impartiality that is supposed to be here. There cannot be a fair trial for all of the amounts of evidence that I have.
Okay. Anything else you want to put on the record before I call the jury in?
Yeah, lengthy statement I would love to put on the record before we get.
How lengthy?
Minutes.
Go ahead.
Respectfully,
Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oak, I respectfully assert this court has failed to by the files of the case. Yeah, well, then so she can make.
Thank you.
I respectfully assert this court has failed to address the critical motions I filed in this case, including a motion to dismiss for lack of jurisdiction, a motion to recuse for bias, and a motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR 10143, which is court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which may be outside the court. In Marbury versus Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the action or lack thereof of the court violate the fundamental constitutional principles. In Murdoch versus Pennsylvania 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right. And Thompson v. Smith 155 reinforced that the fundamental right to travel freely without undue interference. Additionally, Title V USC 556D, 557, and 706 require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concern this court has disregarded these principles, given its pattern of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes, other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence of collusion between the court, prosecutor, Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Sisai, Officer Smith, and Chief Everett Robbins. These violations occurred even after Sergeant Price confirmed that my activities were lawful. Yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I have requested Your Honor's oath of office through an affidavit of fact, registration statement, demand request pursuant to the Foreign Agent Registration Act of 1938, and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Martin issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui jurisdiction. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent my constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORD ordinance was never intended for law public roads. Under the Clearfield Trust Code, verse United States 318 U.S. 363, when government entities operate in commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The supremacy clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of my constitutional rights and an abuse of judicial power. I respectfully request that the court issue rulings on the pending motions, including a jurisdictional challenge, and immediately dismiss this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will seek immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sisai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed under the presumption that I engage in commerce, it must present evidence to substantiate its claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORD ordinances upon me, and any further actions would be unconstitutional and unlawful.
All right, here to court district court back in session.
Bring the jurors in. Mr. Crucell, just so you understand the process, we're gonna do voir dire. Did you have a chance to talk about the iPad?
No.
Hold on a minute, Joe.
Yeah, I told him I would go over it.
Okay, okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an
Because if you leave, I'm going to ask you a bench warrant and you're still going to have to deal with this down the road. At least this way, hold on, listen, here, one of two things can happen today if we have the trial. Either they find you not guilty and you're done, then you can file all your grievances and stuff, or they find you guilty and you're just filing one more appeal.
Instead of wasting everyone's time.
You've already wasted their time because they're all here. They're all here.
Well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too.
So
But hold on. Hold on. Don't interrupt. You didn't appeal the last round of decision. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green, and you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
I had to file with the appeals court. I've been in contact with the appeals court.
Okay. Okay, hold on. Let me try to educate you. Okay. You contacting the appellate court, first of all, this should go to the circuit court. All right. You've gone. Okay. So I didn't choose for you to be here, but you're here. Okay. So we have to get through it. All right. So the way it works is you don't just talk to them about an appeal. You actually file and perfect an appeal, but you didn't perfect the appeal. So there is no appeal. You started the process, but there is no appeal. So we're going to go forward today. The only question is, are you going to be in the chair or not?
No, again, if you were prevent for, I'll have to stay on one, correct?
Depending on what I set the bench warrant at. It can be whatever I want it to be. Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. And I'm trying to, listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this, I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
So that fact that she told me that on the record in front of.
In today's courtroom, one judge proved that justice is more than punishment. It's responsibility with compassion. Throughout the hearing, the judge stayed calm, listened carefully, and treated every case with fairness. Whether it was a traffic violation or a serious offense, he explained the law clearly and gave each person a chance.
And in all the things that she's saying, the judge said, she never said that on the record. I have the record submitted.
So once again,
told me she wasn't doing this because of the Secretary of State.
Then appeal Judge Green's decision. I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right. When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
I've been trying to get all this stuff established with the courts. And I still have evidence that I'm trying to get from the township that they're using lead codes for data, which they did with the policy information that I gave them and got them to give me the policy because they were trying to use link stuff. And I have
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
this is where I haven't got it to even get to.
No, tell me what it is. What,
Evidence that was that I requested through FOIA's in the very beginning with my bottle camera.
no. But what is it? You're looking for some records, some ordinances? What,
Part of the traffic stuff, comments and things that were put in there that
hold on. In where?
in the comments.
You don't have police reports?
Well, I do, but I found out that they withheld certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more, filing for more stuff, I uncovered that they withheld certain documents. That are getting the whole thing.
Hold on, let me hear what you just say. Just hold on. Go ahead. Do you have any idea what he's talking about?
He's pointing things from the south and and,
You mean like the officer's personal notes? Had notes.
and, for example, body on camera where they're sitting in their patrol car and the computer's on. Those are all lien material that can't be discoverable, it can't be shared with people outside of those that are, have the security clearance to observe or handle lien material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking to the chief, that they purposely redacted out of the conversations, and the notes that that are completely all redacted, has nothing to do with computers, it has nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
They withheld this when they should have given it to me in the very beginning with my FOIA for everything that's involved in my traffic stop. They didn't.
Okay, hold on. I'm trying to clarify. Are you talking about like, how do I want to say this? Personal comments between two or more individuals?
No, it's not personal boundaries, it was stuff that's logged through the traffic stop. Like,
No, stop. But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
yeah.
Or edited the recording?
As well, that there was no clear reasons why, every time I try to get reasons to why they did it, what it's next, because they're supposed to label why it is. I haven't got anything, and then it's in the comments sections of like what was going on.
Hold on. Comments on the incident report?
It's not the incident report, it was through the, while the traffic stop was taking place, stuff that was being entered through, like. I can't remember exactly what the paper is I am, like I said, I'm in the process of getting it all. I'm appealed it to the supervisor, and then he vaguely gave, just cited statutes and codes, but he was supposed to tell me how and why I didn't even see the applying to the lead sections, which are failing to do because same thing with.
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected.
Yeah, but I have other.
Hold on. Is that a yes? That's what they're telling you?
Essentially.
Okay.
So, and part of it, because I had a whole thing paper I got from them, they didn't do it in any of the other ones. Only.
Hold on. Other one what?
All the, because there have been several reports, several times the cops came out of their house, and we were told, well, this has been going on for well a year, probably why it's even happened.
Okay.
So I filed every cop that had been there, all the reports, anything to do with anything that I could get that was in access to me. And then that's how I found out that these other reports weren't released to me. And then in my life traffic stop, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. We got any of the other stuff, it's all open.
Redacted from,
The whole page is just black.
hold on, redacted from the incident report?
Yeah, from the incident.
The paper report that you received?
Yeah, exactly.
Okay.
And there was no justification involved to why any of these things are redacted. I keep trying to, and how they did it with the policy. I tried to get the policy 3 separate times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct for officer conduct and how the officer's supposed to operate and stuff, right? So they denied several times, stating the same need codes are trying to use for all these connections now. So I appealed it to the township supervisor, and he released all of my information. And it showed that the policy showed that these officers violated the policy and
Okay, hold on. Stop. So he released everything, but not everything you want?
Well, then once I realized they were doing this, I went back to getting more. That's how I found out there was more stuff that was never released to me.
Okay.
And then they're doing the same process using these lien codes to not let me see what was put in this vehicle. And that's why it's all the American Titans. I've been trying and fighting all this full time trying to get this stuff together. And I'm getting every which way. I'm being screwed.
He's raising issues that concern me. Because now we're talking about discovery requests that are being partially fulfilled.
As you can see, as it is with this stop, he does have the incident report, he does have body worn camera for 4 officers in car, dash cam, what have you. He also, personally took a video, I don't have it, there was no mutual discovery, he elected to use the FOIA, route to take all this information. What he's referring to again is the CAD information where there is no material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about, the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police may have came to his house or like a traffic stop or speeding ticket, there are no incident reports, those are CAD notes. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had to have been written.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually, now that I've been having to really dig into stuff, I'm uncovering more. Now that I've been through the body cams, I have to file more to get more stuff unredacted because there is clear points in these conversations that were purposely redacted. It had nothing to do with lien information that they keep claiming. Same thing with these CAD notes she keeps referring to. That's not what I'm trying to get hold of. And I understand that there are things that they can redact through the lien code. These entire things that are, there's no way the entire pages and these comments and everything are all lien information. And I know that I've been told.
How do you know?
I've been told for Sergeant Price, things that are said in these personally about me and stuff like that are being redacted because it can be used showing the bias and everything, the retaliation against them. And I know for a fact what was said in these things. That's why I know that being redacted is more than much to say.
Okay. But Mr. Crisell, with all due respect, that all sounds like a civil lawsuit against the township.
Well, yeah, this is my arguments. I'm trying to bring into this court, but everything's just being keep getting.
Because I'm not gonna get into all that with a jury.
But it goes directly to this, is what I'm saying, and that's why I've been trying to get all of this stuff answered before we even got to this point.
I'm not gonna let you get into all that with a jury. It's gonna be confusing. We're gonna go down rabbit holes.
That's why
What's-
I'm prepared, because I need to be able to present my case to
Sure.
the fair.
So this case goes back to February. We set this trial 2 months ago.
You're right, but
2
I'm
months and 2 weeks.
trying to get the jurisdiction established, I'm trying to get the judicial bias stuff taken care of, all of these things that have not, that they've just been it is what it is, being swept under the rug, when
Okay, hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it.
without it. I give it, yes.
Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine, and I guess that's something, and I have already started to do process, and I will be going down it, the more I look at it.
Okay.
So again, I,
Sir, it's 9:02. The jury's been here since, I'm assuming shortly after 8, some of them were showing up.
yeah, like I said, I cannot participate in something that I know is not, it is stacked against 100%.
But once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
It shows that these things have to be established, that there has to be any.
Then,
You see, bias, but that, to me.
okay, stop. We're just hashing we're hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you today. If you're right, and this whole thing has been nothing but a sham,
And it has to be, and it's all this turned into.
okay, bring the jury in. I'm tired of talking.
That's the motion will be real quick.
Motion who? Oh, I forgot you filed a motion. Give me just a moment. Yeah. Yeah. Did you see that? Hold on. Did you get her motion?
I've never seen anything.
Yeah, no. Just, you got a copy, you can just at least show him so he can see if he's seen it before.
When did you send this to me?
Last Tuesday along with our motions.
I have never seen this.
Take a minute to look at it.
Let's like to bring up for the record too that.
Hold on. Hold on. Have you had a chance to look at what you just handed me? Okay. All right. So are you ready to argue that motion?
Well, no, I had no time to prepare for anything except. I've never seen that before, and
Okay.
it's just trying to keep me from being able to bring up all my valid arguments that are all applied to this.
Once again, valid as you determine them,
It's advanced to the case.
as you say.
And that's, and they're saying we go the things they're trying to say, right? They have no evidence. Where's the evidence, right?
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my.
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
All part of this case.
Okay.
Same thing with all the traffic stop all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm again trying to get all the other matters. I'm not ready for that. So I've never even seen it, so I can't even build up a defense to that. To produce.
How was that provided to Mr. Crusoe last week?
That's responsible.
Okay.
I received his motion or his 109 motions on Thursday, so it didn't give me much time to respond. I did send it in the mail, I dropped it off at the post office. And I didn't receive his most recent motion.
That was filed Friday. Right.
I said on my certified mail, so I know what you're saying. I mean, we've never got first last name. Never.
All right. So here's what we're going to do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as a point on a point by point basis. Understood? I'm not, sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. I'm not going to do that. If you choose to present anything to the jury and one of these topics come up, she's going to stop me probably with an objection, say, Judge, could we talk about that? And then we'll talk about that. Item by item. Understood? All right. Anything else before we bring the jury in? You said you wanted to say something before the jury came in. I thought you said.
Another key point to this, I filed for records requests in court, trying to get all my court hearings and everything in order. There's still one from the very first one from Judge Martin that is crucial to this case. They still have issues.
How could it be crucial to the case today?
Yeah, second rule in there, absolutely huge to all my whole.
No, they're not. No, they're not.
All of this.
No, sir, everything started on February 3rd, 2024, when your tickets were issued. So anything,
Then I think it's default.
let me answer. I'm trying to be patient, Mr. Crusoe. Anything Judge Martin said at a hearing about those tickets after February 24th, February 3rd, 2024 would not affect the facts of what happened on February 3rd. Agreed?
But it affects what is going on with this court, as far as the fact that.
The only thing that's going on with this jury is deciding what facts took place on February 3rd and how they apply to the ordinances the township is trying to apply.
Yeah, then it's going on with that, but again, like I said, I'm not gonna subject myself to sitting here through something that I know.
Then get up and leave, Mr. Crisell. You're not under arrest. I've already explained your options. I've tried to be as clear as I can with your options.
Like I said, I'm not participating in this. It's clear there's all sorts of stuff going on here that's right against me.
I understand you feel that way, but I've got a trial scheduled today. Something's going to happen. Once again, if you get lucky, they find you not guilty and you're done with this stuff.
Can I take a minute to figure out what I want to do with this?
Absolutely. Oh, one thing I want to make clear. The civil infractions don't go to the jury. You understand that? That's a formal hearing. That's just between us. You understand that? We'll deal with that after the trial if we have a trial today. The misdemeanors will be in front of the jury. You understand that? Okay, take a minute. Make it quick though. I hate to have the jury wait. Mr. Crisell,
Yes.
Mr. Bowditch is available. Doesn't cost you a thing just to get his opinion. All right. Go for a trial on Clay versus Park Estates. Mr. Clay, you ready to roll?
Yes.
All right, counsel, your appearance for Park.
Seven, turning on the gas.
Okay. Let's get started. Any opening statement or you just want to jump into testimony? Yeah, go ahead.
I took over that brother, my mother passed away on 5/8/24. And my brother was evicted on 10/23 of 24. And I sold that trailer to a guy that backed out of the deal, started suing me too. I don't know if you recall that.
I don't.
But we did lost. But I tried to sell it again and the apartment manager refused to let me sell my trailer. Because he said that other guy had a pending lawsuit against me. And so I went to trial for hearing and he never showed up. I got dismissed and I took the dismissal to the park manager and said, now I can sell my trailer, So I went to the second hearing to be filed. And he didn't show up at court again. And I took the second dismissal. He said it would check with his legal department. And he still didn't sell his trailer. And then I talked to the manager that she's above the park manager, operations manager, or district manager. And she said, well, you didn't sell your trailer, we don't. But after they said yes, they said I owe $7,500. I could have sold it that month of November. The other guy backed out on the 31st of October, and I got plenty of people.
Okay, let me stop you, because this sounds like you're telling me your whole case in testimony. All right, well, you understand, nothing you're saying right now is going to be used in my decision-making because it's not evidence. It's just an open statement. Okay, all right. Anything else is by way of opening? Okay. Opening or reserve? Go ahead.
This is a case where the goalposts have been constantly moved. Mr. Clay filed an amended complaint April 29th of this year. We had at least one pretrial subsequent to that date. And at that time, I explicitly asked Mr. Clay whether he was going to stick with the allegations in the April 29th suit. Because those allegations superseded basically everything that he's just stated. The original lawsuit involved alleged interference with his right to sell the trailer. Claim delivery case has nothing to do with that. And Mr. Clay explicitly indicated that this was what he was going to rely.
Just to make sure in my memory, the amended complaint took it to a claim and delivery, correct? Okay, go ahead.
So anything above and beyond the allegations in the complaint, I would argue are irrelevant for this trial based on the acknowledgement Mr. Clay made in the pretrial. Further, Your Honor, the eviction itself was completely proper. Pursuant to case number 24-6294 LT, which you also presided. A judgment of possession was entered in that case in favor of my client and against Mark Clay, who actually gave permission for his name to be signed. It was a consent judgment. That required all rent to be brought current by September 27, 2024. When the rent was not brought current, an order of eviction was submitted, which you entered on October 7, 2024. The eviction then was carried out. Now, the claim and delivery complaint claims damages for basically, I guess, the wrongful taking of certain property pursuant to the order of eviction. I would argue that Michigan case law is very clear and Michigan statutory authority is very clear that my client is immune from any damages because the items that were removed pursuant to the law of the issue.
Okay, all right, thank you. All right, ready to present your case? Okay, do you have any witnesses or are you going to testify? Okay, counsel, are you all right if he just stays where he's at after I swear him in? Are you okay if he stays there to testify instead of? Yeah, and you'll let me know if you're not picking him up. He seems to be loud. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth today? All right, so give me your testimony.
Well, testimony is, I took over for me and name on the pathways.
But let's get to the point where you file the claim and delivery saying that they owe you money for property. So let's get to that.
I started with them. And some law firm that helps people.
Okay,
You talk about the claim and delivery, I have no idea about that.
okay,
And, they took my property from my trailer, they had no right to enter my trailer under Michigan law, I got the right to enter. Says they cannot damage the property, your property stays yours, if they say they did it under Michigan law, they didn't do it under Michigan, mobile home law. It says they cannot damage my property or take my property. Maybe later, when, the cost occurred, I had it all paid up. They just let me sell my trailer and this would have been done longer.
okay, so what property was damaged?
Fishing tackle, a lot of my property, they loaded everything in the trailer. Into 3 trailers, in my mobile home, into 3 trailers, it was took into the landfill. On the 23rd of October, 2024. And they had no right to enter my trailer. They had the right to evict my brother. And, but they didn't have no right to take his property or my property because that's my trailer. That, they say that you signed an order saying they can do that, but I don't see how you can really do that.
I didn't sign an order that said they could take personal property out of the trailer and put it to the dump.
But that's what they said in a little meeting we had. The judge signed the order said that. I don't think that unless they put a fraud on the order saying that it was their trailer or something. But, yeah, that's my case about my claim.
Okay, but you understand with the claim and delivery, you have to establish value of the property and exactly what the property is and so on and so forth. Because a claim and delivery is saying, Judge, I want my stuff or I want the value for my stuff.
I got it in my filing.
In your what? I'm sorry? Your filing is not evidence. Your filing is not evidence. I make decisions at trial based on evidence. So you have to present the evidence today if you want me to consider that in my judgment. You understand what I'm saying?
I mean, but I can.
I don't know what to tell you. You've chosen to get into this arena without counsel. It's not fair for me to try your case for you and leave him to defend himself or his company. I can't help you present your case. All right, so I'm going on a limb when I tell you what you're supposed to be doing right now is establishing the items and the value for those items if you want me to give you a judgment of money for the missing items.
All right, well, I have some tools. I mean, you want it written down? How would you like this?
Once again, I can't tell you how to present your case to me.
I have some tools that were missing, that were taken out of my shed and my home. I would value them at about $7,500. It was taken. And they took my dad's flag, his military flag, which I considered out the price was that was in a box in the house. And they took about, I put it down $10,000, they took about $30,000 for fishing tackle, but I used to be on,
Well, my limit is $25,000.
and then they took some furniture, couch, and some clothing. That's what I put down there as the amount. I know,
Okay, but once again, your filings aren't part of today's record at trial. So you keep saying, I put it down there, I put it down there. You've got to talk about it today
you know,
as sworn testimony.
$3,000 worth of small appliances they took out. And probably about $1,000 worth of clothes. And my dad's flag and some, living furniture, which was about $1,200, I can say. That's my personal property.
All right, anything else at this time?
I would just like to say that, I don't feel, they filed a claim against me for the rent. I don't feel,
Let me stop you. That's not up today, is it? Did you counterclaim for rent? Okay, all right, go ahead.
okay, once the manager told me I didn't sell my trailer, I just figured the rent wasn't, due. I never got a bill on that rent. But, and I still haven't got a bill for rent. Any kind. Like I said, it just kept adding up. They never sent me any kind of invoice. They never signed anything with the park saying I'd pay the rent. I just wanted to sell my trailer and get out of the deal. That's all I wanted to do.
Did you ever sign any kind of lease with them? Anything else?
I got my witnesses.
Okay, well, once again, it's your case to present. You decide how to present your witnesses. Come on up, sir. No, hold on. Stay where you're at. Would you like to cross-examine this, Mr. Clay? Go ahead.
Yeah, any documentation with you today of the values of these items that you claim. You have no independent verification today. Okay. So basically, the court simply can't take your word for it as found as part of evaluation.
Just,
Okay. The fishing tackle, when did you buy it?
I started fishing in, a lot of the old stuff, early as 1990 up until, 2010.
So you used it obviously often during that period of time.
Yes.
So it's appreciated, correct? I don't think so. You're guessing that it didn't. The tools also were used.
Yes.
Okay, so again, could have appreciated. Your dad's flag, is your dad still alive?
No.
Was there a probate estate?
Open. I know,
Were you ever appointed personal representative of the estate?
yes. Oh, my mother.
Your mother. Okay, so your mother would be entitled to act under the estate.
My mother was dead on the flag, it's spirit, so that was mine.
Right, did you open a probate estate for your mother?
No.
Okay, so there's no court order that permitted you to act on behalf of your mother's estate or your father's estate.
Well, I inherited all my stuff from my mother, so I guess the flag is mine.
Couch, clothing, again, depreciate, all used.
Yes.
And small appliances used, clothing used.
Yes.
And you don't have any valuations today of any of these items.
No.
Including or not including depreciation.
Right.
You do not dispute that a judgment of possession was entered by Judge Oakley against your brother on September 13, 2024.
I don't know what day it was one around there.
No. Go ahead and get that. Our missing exhibit. I'm not giving that. Oh,
Taylor.
You will copy the document, not the defendant's proposed exhibit 1, and ask you if that is, to the best of your knowledge, the judgment of possession was entered in the case against your brother.
Yes. That's
And, okay, and it was approved by Judge Oakley, if you look at it, September 13, 2024.
Yes.
And it provides that the sum of $1,491.46 has to be paid by September 27th. Is that correct?
Yes.
That's paragraph 4. And if it's not paid, then my client would have the right to apply for an order to evict your brothers.
Yes.
Okay. Now, was that going to be paid by September 27th? I'm going to give you what's been marked, or is going to be marked as finished proposed exhibit 2, and ask if you can identify.
What was that?
All right. I'm going to give you what's been marked as finished proposed exhibit 2, correct?
Yes, yes.
All right, and that is an order of eviction. That was approved also by Judge Oakley, correct?
Yes.
And that order of eviction provides that my client is entitled to be brought to immediate possession of the premises, correct?
The property.
The immediate possession of the property. Yeah. So, based on what you were told by an attorney whose name you disclosed, it is your belief that my client did not have the right to remove anything from that trailer. That's correct.
I'll take judicial notice of that fact.
There's law that says otherwise.
I'd like to see it. Trailer wasn't yours.
I will, I'm glad to go with a copy of it.
Love to see it.
So, I guess the question that I have for you, well, I won't even ask it because the case law speaks for itself and I'll quote it later on. The order of eviction was carried out, correct?
Yes.
A court officer pursuant to the order of eviction.
Yes.
That's it is not representatives of Park Estates that came in.
Okay.
Well, they court officer was
It's
entitled.
kind of a record.
The court officer works for the plaintiff in an eviction counsel. You know that.
Well, but the order of eviction instructs the court officer to restore the plaintiff possession.
Of the lot. Of the lot.
I'll respectfully disagree with the court based on the case law that I think we have.
Okay.
Now, your brother signed the lease for a lot.
Yeah.
You know, so. So it's your testimony that nobody signed the lease for a lot?
My dad signed an application for when the other company was the owner of the trailer park. I don't know what we're called these, but
But your brother signed the judgment.
okay,
Approved the judgment for entry, correct?
for the eviction,
Yeah.
yeah, I guess, okay. I was there. Was your brother living there?
Yes, he was. And this was not the first case that was brought against him for eviction, correct?
I believe it was.
There was not another case that was filed in April of 2024.
Not that I know of.
Might not have further on.
Okay. Okay, so I'm gonna take that. You testified as direct. This was crossed. Do you have anything now under redirect, or you want to put your brother on the stand? Come on up, Mr. Clay. The other Mr. Clay. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today? Come on up here and have a seat. Your first name is Mark?
Right here.
Yeah, right there. Settle in that chair. All right. Plaintiff, Mr. Clay, you can ask questions of witness, Mr. Clay. Go ahead.
The first week of November, seventh grade, recall day, did I ask you to come in and listen to a phone call between me and Eddie?
Yes, you did.
And, you recall what Eddie said?
You can actually hear it because it was under oral support. It was something to do with the
The lawsuit.
Your Honor, all object on the basis of relevance. Once again, this has nothing to do with the claim delivery. It has to do with the original complaint that Mr. Clay filed, which was superseded by his own admission.
So claim and delivery is, you're saying they took your stuff, you want your stuff back. If they can't give you your stuff, you want the value for the stuff. So how was that phone call? Who's Dave, by the way?
Yeah.
All right, how is the phone call between you and Dave relevant to that? Okay, move on.
Did the court officers empty our trailer?
yes, they did.
Everything,
Everything.
and the shed? That give an accurate description of my property?
Yes, very good. Yes.
And you lost property?
I lost about $40,000 myself.
And are you gonna file a lawsuit?
Yeah.
That's all I have, Mr. Engineer.
That's,
Hold on. There's no question, no answer. Cross?
Mr. Clay, you approved the entry of the judgment of possession. That was exhibit 1. Show it to me.
I don't know,
So yes or no questions? You approved it for entry.
yes,
And you didn't pay the rent.
correct. Yes,
And therefore, there was an order of eviction that was issued by a court and carried out.
yes.
Nothing further.
Okay, any redirect of Mark?
Well, did you feel you was under arrest by, you had to let them in?
Yes,
That's all you're gonna.
Any recross?
And there was a court order that handed down to effectuate the eviction. True?
Yeah, Your Honor.
What's your objection?
What's that?
What's your objection?
Well, it's stating, court order said they can enter. Basically what he said, he's gonna show us the case law. We've seen that yet, so I don't think that's any proper question.
I think to put it in legal terminology, that would be lack of foundation.
I'm not sure necessarily law has a lack of foundation, but let me see if I can establish. Mr. Clay, there was a judgment entered, you didn't pay the judgment, correct?
correct.
And the judgment provided that Park Estates would request and have issued an order of eviction if you didn't pay the judgment. Sure. Right, and you didn't pay the judgment, so they requested an order of eviction. And that order of eviction was carried out. Nothing further.
All right, you can step down. Any other witnesses? Ms. Arnold, come on up. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? Come on up and have a seat in this chair. When you're ready.
You were there on the day of the eviction?
Yes,
You seen them court officers carry out all the property?
yes,
And they left nothing.
they left absolutely nothing in there.
That's all I had to know. She don't know all that stuff about you.
Okay. Cross?
You have no idea of the value of any of these items that were in the home.
Some of them I do because it was my kids' items that were there too.
Do you have receipts or anything to establish the value with you today?
I don't have nothing because they took it all out.
But Mr. Clay seems to have given estimates of what he believes the value would be, without again any established receipts or anything to show documentation. You have no documentation of your day item, correct?
No, because
And
it
you
was
also haven't brought a suit. Did you give any kind of authority in writing for Mr. Clay to pursue a lawsuit on your behalf?
not in writing.
All right, Mr. Clay's not an attorney, is he?
No,
So he's not your legal representative today?
no.
Nothing further.
Any redirect? You can step down, ma'am. All right. Plaintiff, Mr. Clay, anything further at this time? Counsel?
Your Honor, defendant moves for a directed verdict based on Brown versus Real Estate Management Specialists 2021 Court of Appeals case.
You have a copy for him.
I'm going to quote directly from that decision. Plaintiff argues that defendants operated outside of the scope of the eviction because they were not entitled to enter plaintiff's home, remove her personal property, and dispose of it in a trailer. We, the Court of Appeals, disagree. The possession judgment advised plaintiff that she had to pay $3,519 by May 14, 2018, or leave the premises. It also advised that an order of immediate eviction could occur for the failure to comply, and that partial payment was insufficient to stop the eviction, which, by the way, is what the judgment provides in this case. And that we provided in Exhibit 1. It is difficult to discern how plaintiff believes that she could be compelled to leave the premises, but allow the possessions to remain. Indeed, the judgment granted possession to the plaintiff or the defendant in that case. And the order of eviction directed the court officer to restore the plaintiff to and put the plaintiff in full possession of the premises, which is exactly what the order of eviction states in this case. To state that REMS, which is the plaintiff in that case, would be granted possession of the property, obtain the right to evict a person, but would not permit the removal of the person's belongings, would deprive REMS of the use of its property. After a lease is forfeited for non-payment of rent, the landlord may obtain lawful possession and forcibly remove personal property which does not constitute a breach of the peace. There is no indication that plaintiff attempted to negotiate with counsel for REMS for a date certain to remove her belongings, despite previous negotiations. This claim of error has no merit.
What were the premises in Brown?
It's a trailer.
Who owned it?
It was owned by, well, it was leased to Brown, who was the plaintiff in the case. She's the one that was claiming damages for the removal of the property. REMS, the defendant in that case, was the party that obtained the order of eviction.
Okay, at one point you said REMF was plaintiff. That confused me.
But it was plaintiff in the eviction case.
I'm sorry, plaintiff in.
It was plaintiff in the eviction case. I apologize. So that's word for word quoted from the opinion. I will provide you a copy.
He said one thing here.
Now,
Hold on. Not your turn yet.
it's not the only case that provides community for carrying out an order of eviction. I would also refer the court to Term Ministries versus Bank of America, also a Court of Appeals case decided in 2011. And the landmark case in that area is a case called Sickles, Sickales, from 2007. Barnaby versus PCI also is on point. That case is a 2015 Court of Appeals case. There's no question that my client and the court officer are entitled to immunity, statutory immunity, and I will cite the statute. It's MCL 600.2918 is the applicable statute.
2918.
Yes, providing for it. So, combination of all these cases together plus the statute, I would submit that my client had the absolute right to remove Mr. Clay's belongings from the home, and therefore, on that basis, my client would be entitled to the directed verdict. Further, Mr. Clay has failed to meet his obligations with respect to the claim and delivery claim. He has not provided this court with any kind of documentation relating to the value of these various items that he claims were wrongfully removed. Some of which go back more than 20 years and certainly have appreciated over the course of time. Mr. Clay provided nothing in terms of how the items were obtained, provided nothing in terms of who purchased them, what the purchase price was, and any kind of appreciation for it. So therefore, he has not met his burden with respect to claim and delivery claim either. Under either or both of those theories, my client would be entitled to a direct verdict.
Response.
In his first one, when he gave me, he said that it was a lease trailer. In this thing, so the lease trailer, sure, they can come up.
Even that state said it was a gray area that I let them just get bought.
Let me stop you. I took it from your explanation of ownership on the Brown case that Brown was leasing from a third party, not from REMF.
And I don't believe that's the case,
Okay,
but I will let me clarify.
sure, sure.
She leased the home from a private landlord. REMS was the management.
For who?
For the-
Yeah, so she was being evicted by the owner of the trailer. That's not on point with this case. That's not on point with this case, and it's disingenuous for you to imply to the court that it is.
I disagree on it.
How do you disagree? It's a different owner of the trailer. Owners have different rights than the park owner of a lot.
Your Honor,
The person that owned the trailer Brown was living in had Brown evicted, and as part of that eviction, she lost personal property. That's the same as an eviction on an apartment or a single-family residence. There's a complete body of statutory law dealing with evictions of mobile homes that's not there.
so with the termination of tenancy case, Your Honor, they would have had 90 days to sell the home. This was not a termination.
But my point is you're presenting Brown as if it's analogous to our situation here, and it's not. It's a completely different fact situation. Well, guess what? I'm wearing the black robe and I say it's not. So Brown is not in my decision-making today. So if you've got something that's analogous to this fact situation where you were evicting a trailer off the lot that you own, but you had no ownership interest in the trailer, then I'd love to see that case law.
The Turner case, Your Honor, once again, is a claim that there was wrongful movement storage of personal property.
Let's start with who did the eviction and who owned the trailer. Go on.
Once again, there was a claim that there was a wrongful removal of property that was taken to a storage facility. The court held that the removal was proper.
But who owned the trailer?
It was foreclosed upon by Bank of America.
Okay, so Bank of America was the owner.
It wasn't foreclosed. I agree.
Yeah, but they owned it. At the time of the eviction, Bank of America owned title to the trailer, correct?
Yeah.
Who was evicted?
The purchaser.
By Bank of America, the owner. So once again, totally different fact situation than Clay versus Park Estates.
Finally, in Barnaby versus PCI, it also is an order of rejection. And the claim was that
Don't tell me the claim. Who was the plaintiff in the eviction?
was the landlord.
The owner of the unit.
I don't believe so, but let me.
Well, if they were the landlord, if they weren't the owner of the unit, how were they the landlord?
Because they leased me.
So they were acting on the auspices of the owner. I lease it from Clay. Clay rents it to Landman. That means Clay is the owner for eviction purposes.
I don't, I understand what the court is saying. I don't believe that it is separate and distinct because of the fact that you have an order of eviction.
My eviction authorizes the court officer to get a trailer off your lot, not to go in and dump all the property to the dump. Never in my tenure on the court have I said to the court officer, go ahead, take personal property out of a trailer that the plaintiff does not own and throw it away. That's not what my eviction orders are meant to do.
The eviction order, and in this case, in the case that I provided, and in all three of these court of appeals cases, instructs the court officer.
Counsel, you're not catching what I'm laying down here.
I know exactly.
Your client did not own the trailer that the eviction took place at. So all those case laws, the evicting party owned the trailer. You're talking apples and pork chops. We're not even all in the same fruit basket here. So I hope you do. I hope you appeal it. So let's talk about your other reason for the directed verdict. What statutory or court rule authority do you have that I can't take testimony alone on value?
Testimony, Your Honor, it's got to be supported.
Where's that at? I'm asking you for the court rule.
Claim the raise is 3.1. I think it's 3215.
Take your time. Sure, we'll take her. Counsel, take your time. Mr. Clay is going to go get a drink. No, he wants a break to get a drink. Go. Just don't talk while he's out of the room.
Your Honor, the court rule is 3.105. 3105C2
Hold on a minute. Okay, I didn't know he was back yet. All right, go ahead.
requires that the value be stated.
I'm sorry, counsel, 3.105, what? Right,
3.105C2 requires that a complaint state the value of the property, which is not an admission of value. So therefore, in order to establish value, the proofs have to be stated. You have estimate from Mr. Clay. You don't have any supporting documentation whatsoever. Yeah.
okay, anything else?
Can get foundation for value to consider.
Once again, I can't tell you how to present your case, but you don't have to have original receipts to establish value. I said, original receipts for purchase is not the only way you can establish value of an item to the court. Anything else? Okay. All right, counsel, grant your motion. Let's move on to the counterclaim.
Your Honor, as I looked at the counterclaim, the judgment was against Mark Clay. So I do not believe that George Clay would have stepped into Mark Clay's shoes. So with that in mind, if Mark Clay decides to file a lawsuit, we will go ahead and pursue a counterclaim against Mark Clay.
I think that means you're dismissing your counterclaim. You're right. I'm sorry? Any objection to the trailer being sold?
If the trailer is titled in George Clay's name,
Who's got the title? All right. So I'm just hearing that that's the only worry they.
Well, $16,000 they say that rent. And that's why they have.
Okay, well, he just admitted you don't owe any rent. He just said he's letting his counterclaim go because you're not the responsible party for back rent.
See that? Okay.
That's what I just heard.
I'm not letting it.
Okay, all right.
there may be future litigation. But I suppose if that occurs, then we'll have the issue of whether there are claims that should have been claimed here. Because maybe it's a claim.
I don't like to talk about how many angels can dance on the head of the pin. So if it comes up, we'll deal with it then. All right, questions?
Well, that, tell Parker State that I can only rent and I can sell my friend.
There's rent room for the lot.
which has nothing to do with the trailer. Would you agree?
Doesn't have anything to do with the purchase price. Home's been sitting on the lot for now several years.
Because you wouldn't let him sell it. Your client told him they couldn't sell it. So now you're telling me they can refuse to let him sell it and then say he can't sell it now because the lot has too much back rent on it? Then we're going to be back here for another claim of delivery because you've forcefully taken the trailer.
Well, I don't believe that we have filed our own claim of delivery. That has to be.
No, my point is you can't, on the one hand, you can't say, sure, go sell your trailer. And on the other hand, say, but you can't sell it now because there's too much money owed on the rent and somebody's got to pay us that. You can't stop him from selling the trailer and then hold him responsible for the lost time. So the man needs some direction. Are you authorized to tell him, put it up for sale and get it out of there?
The authorization to try the case based on claim delivery of the spot.
What about your family?
He just dismissed that. Yeah, but he just dismissed it.
Okay, but
And I can't stop him from dismissing his case. Right. So I think what I'm hearing from him is you got to sue Park Estates because they've taken your trailer.
okay.
Have they deprived you of its use and value?
Yes,
That's a taking.
and they have, last year, they made the local office.
You got to go see a lawyer, Mr. Clay. You got to go see a lawyer. Because a lawyer would have walked out of here with a judgment against them today for claim of delivery. And I know it's throwing good money after bad, but good luck. Have a nice day.
Or the judgment about it.
Yeah, I think, Carly, we got to e-file that judgment, don't we?
Yes, Judge.
Yeah. Thank you, Mr. Lehman. All right, Jamie, would you turn that TV off?
A great judge doesn't just enforce the law, he earns respect through fairness, patience, and integrity. In this hearing, the judge handled every case professionally, making sure everyone understood their rights and the legal process.